As SCOTUS drags feet, innocents suffer. Welcome to Law and Society. Please subscribe and let's get to it. The Supreme Court is playing the waiting game, and that's just, it's inhumane, okay? I think that the Supreme Court and Chief Justice Roberts is so far removed from the actual conditions in which these people are being subjected to live, 75% of whom have no criminal record, that instead of going with the district court's ruling that you bring Mr. Abrego Garcia back, they have decided to lift the order to bring the Maryland man home. The order, the Supreme Court Chief Justice Roberts issued an order for the government to reply, and it seems like a quick turnaround time. But the premise of this is that this guy was given a protective order by an immigration judge, specifically not to send him to El Salvador. But the government did anyway as an administrative error. And don't tell the court or don't tell us that it's difficult to bring Mr. Garcia back because Kristi Noem can go and visit the prison whenever she wants, and we are paying them to keep these people. So it is clearly possible for the government of the United States to have access to that prison to the point where the Secretary of the Department of Homeland Security can do a photo op and a video op in front of one of those jail cells. So I think instead of staying it, the Supreme Court has the record. The Supreme Court has the district court's ruling. The Supreme Court has the appellate court's ruling. The Supreme Court really didn't need its own briefing and argument on this because the case is clear. But the Supreme Court decides that it wants to go through it in this deliberative manner while Mr. Garcia is exposed to the acute risk of violence and bodily harm, because that's the reason why he was given his protective order by the immigration judge to not be sent to El Salvador. Now, the second case is the one which is about the rest of the Venezuelan or rest of the people who the government has sent to this El Salvador prison. And those deported, the court says in that case that those deported will have to file habeas motions in their venue of confinement. The court says that, there is due process of law. But he lifts the stay, essentially saying that the government could keep on doing this, but not in so many words, but essentially also saying that there's due process rights available. I would assume that that the government wouldn't defy this order of the Supreme Court and keep deporting people to the El Salvador prison, because that would be not following the order that there is judicial review here. So there are a few excerpts from the case that I would like to read to you that I found. It was a small couple of pages, but it's still important for us to understand. So the majority writes, which is a 5-4 majority, regardless of whether the detainees formally request release from confinement because their claims of relief necessarily imply invalidity, of their confinement and removal under the Alien Enemies Act, their claims fall within the core of the writ of habeas corpus and thus must be brought in habeas. So a writ of habeas corpus is used to bring a prisoner or other detainee before the court to determine if that person's imprisonment or detention is lawful. A habeas petition proceeds as a civil action against the state agent who holds the defendant in custody. So that's explained to you what the writ of habeas corpus is, and saying that, you know, that is what the approach should be. Instead of being under the Administrative Practices Act, it should be a writ of habeas corpus, which means that file this case in a writ of habeas corpus at a different venue. Although judicial review, and I'm going to read that part, although judicial review under the Alien Enemies Act is limited, we have held that an individual subject to detention and removal under the statute is entitled to judicial review. So even under that act, they are entitled to judicial review. As to questions of interpretation and constitutionality of the act, as well as whether he or she is in fact an alien enemy 14 years of age or older. So that's one of the requirements from the AEA. So bring them back, and I'm saying bring them back. The court says that there is judicial review. It is well established that the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. So the detainees are entitled to notice and opportunity to be heard appropriate to the nature of the case. It's part of the majority ruling. This is the ruling. So I would think that the government would stop its deportations without due process of law. More specifically, in this context, the Alien Enemies Act detainees must receive notice after the date of this order that they are subject to removal under the act. So that's what put the stop on the government from continuing to do so. And if there is a violation of it, I'm sure that there will be lawsuits that will challenge that and would go to the Supreme Court quite quickly. The notice must be afforded within a reasonable time and in such a manner that will allow them to actually seek habeas relief in the proper venue before such a removal occurs. The venue lies in the district of confinement. Now, how do you reconcile that in this situation when you have the confinement in El Salvador? The proper venue would have to be the District of Columbia, because these are aliens who have already been deported. It's almost as if the court here is just saying that those people who have gone, they're not providing a sort of relief for them. Instead, saying that there's a writ of use a writ of habeas corpus, and the proper venue is a venue of district of confinement. So I would assume that the district of confinement where they were last confined before they were deported to El Salvador is the proper venue. So it's an unfavorable venue. If you think about, I think if they were first detained in Texas. When it's quite easily interpreted as it can easily be put in the District of Columbia venue, because these people are now under the jurisdiction of the United States, but not really in any specific district because they're out of the United States. That would have been a more favorable ruling, and that would have been just as valid as a ruling that's being made here. This is a case of first impression. If you say the proper venue is before district of confinement, in a way you're talking about prospective people whom you are vesting the due process rights on, and really not talking about the people who are suffering right now. So your process has just extended their time in this cruel and unusual prison and punishment for longer than they have to be. So neither is Garcia coming back by midnight, which is past, and neither are these people getting their due process under the rule of law until habeas corpus writ of habeas corpus is filed in the district where they were last confined when in the United States. What other district could you pick for them? The other district would have been the District of Columbia. That would have been DC, because these people are now not in any jurisdiction of confinement. They're not in any district of confinement. But the Supreme Court decided that they wanted to fracture the case, and now the writ of habeas corpus has to be brought for everyone who is there, and their attorneys are going to have to go through the hurdles of saying that, no, this is the proper venue for confinement per the Supreme Court's order. And the Supreme Court could have just very well said, no, bring them back. Give them their due process of law in their district of confinement. Not just esoterically say that, yeah, there is this due process of law that has to be given to aliens. And, I take some sort of, there's sort of a, I don't know, flippant brush of your pen saying it entitles aliens. It's a precedent from 1993, so aliens was okay. These are people. These are illegally detained people who are detained without due process of law. And the Supreme Court could have very well have said that, yeah, this is fine under the Administrative Practices Act, and this we're ordering now for these people to be brought back. Could have done that. My constitutional law professor used to say that the Supreme Court can do whatever the fuck it wants. Whenever we used to talk and argue about what would happen with marriage equality, because, Obergefell wasn't the law then. So, with that said, I mean, I am just like, okay, fine. It's not a bad ruling. It's not a good ruling either. But it keeps these people in limbo and in a hellhole. Chief Justice Roberts and the court did not consider the humanity and inhumanity of their ruling. And I don't know if justice is inhumane. Justice is blind, but justice isn't supposed to be inhumane. And due process of law is not a suggestion. And why would you make a prospective order for venue lies in district of confinement in a case where the district of confinement right now is El Salvador? So what is your interpretation? Where they were last confined or the District of Columbia? It's ambiguous about that. So we'll see what the lawyers do. It's horrible that Andre and Mr. Garcia and these kids from Venezuela who are seeking asylum and these people who don't have criminal records, 75% of them no criminal records, are suffering in what is really a gulag prison where, there was a 60-minute segment on it. That just look up 60 Minutes on YouTube and you'll find the segment. It's their latest segment, and it shows what way these people are dehumanized, their heads shaved, and then put into these general mass detention rooms, jail cells, where you only have a steel plank that are stacked in 3 bunks for you to sleep. There's no sheet, there's no cover over you, nothing. There's no pillow, forget a pillow. Just these steel sheets, these steel bunk beds. And that's what we are subjecting these people to without due process of law. The Supreme Court didn't consider the inhumanity of that, the cruel and unusual nature of that, the unprecedented nature of that. Because I don't remember the last time we deported people without due process of law to a foreign country for them to hold on our behalf while we paid them. I don't remember this happening. If any of you can think of this happening, I'm not talking about some variation thereof, but taking people who are in some way suspected of being criminals and deported without due process of law to a foreign country, not being detained on American soil, sent away to a foreign country. And then the government saying we can't bring them back. I don't remember a case like this ever happening. And the Supreme Court could have done better. With that said, thank you for listening. Please like and subscribe and share and tell people what's happening with our government, including our Supreme Court.